California's new privacy law is tough. How far will companies go to comply? Millions of people in California are now seeing notices on many of the apps and websites they use. Do not sell my personal information, the notices may say, or just do not sell my info. But what those messages mean depends on which company you ask. Stopping the sale of personal data is just one of the new rights that people in California may exercise under a state privacy law that takes effect Wednesday. Yet many of the new requirements are so novel that some companies disagree about how to comply with them. Even now, privacy and security experts from different companies are debating compliance issues over private messaging channels like Slack. The provision about selling data, for example, applies to companies that exchange the data for money or other compensation. Evite, an online invitation service that discloses some customer information for advertising purposes, said it would give people a chance to opt out if they do not want their data shared with third parties. By contrast, Indeed, a job search engine that shares users' resumes and other information, posted a notice saying that people seeking to opt out will be asked to delete their account. The issue of selling consumer data is so fraught that many companies are unwilling to discuss it publicly. Oracle, which has sold consumer information collected by dozens of third-party data brokers, declined to answer questions. T-Mobile, which has sold its customers' location details, said it would comply with the law but refused to provide details. Companies have different interpretations, and depending on which lawyer they are using, they're going to get different advice, said Kabir Bade, the chief executive of OneTrust, a privacy management software service that has worked with more than 4,000 companies to prepare for the law. I'll call it a religious war. The new law has national implications because many companies, like Microsoft, say they will apply their changes to all U.S. users rather than give Californians special treatment. Federal privacy bills that could override the state's law are stalled in Congress. The California privacy law applies to businesses that operate in the state, collect personal data for commercial purposes, and meet other criteria like generating annual revenue above $25 million. It gives Californians the right to see, delete and stop the sale of the personal details that all kinds of companies, app developers, retailers, restaurant chains, have on them. Businesses will have to treat that information more like it's information that belongs to, is owned by and controlled by the consumer, said Xavier Becerra, the Attorney General of California, rather than data that, because it's in possession of the company, belongs to the company. Some issues, like the practices that coup. For more on this story, visit the news article link.